Good morning. Happy Friday. I've had some questions, and they seem to be legitimate questions, so I figured I would answer them. Solicitation and conspiracy are two entirely different things. Think of it like, sexual assault and murder. Two entirely different things. Now, you could have murder without sexual assault, and you could have sexual assault without murder, because they're two entirely different things. But you could also have sexual assault that leads to murder, right? Same way with solicitation and conspiracy. Solicitation, all that has to happen is a person has to offer a thing of value to someone else to commit a specified offense. In Nevada, it's a specific offense. There's a specifically enumerated list of offenses that you could be guilty of soliciting. The other person doesn't have to accept. Once you've made the offer, the crime of solicitation is complete. So you could be charged at that point. You could, in theory, be convicted at that point. You could, in theory, be sentenced and punished at that point. Conspiracy is different. Conspiracy, two people have to reach an agreement to commit a crime. In Nevada, you don't even have to take a step towards completing the crime. You just have to reach the agreement. Once you've reached the agreement in Nevada, the crime of conspiracy to commit any crime is complete. There's no specifically enumerated list of crimes that you have to do to be guilty of conspiracy. Now, conspiring to do certain crimes carries a higher penalty than conspiring to do other crimes. But if you conspire to do any crime, that's a crime in Nevada. So only some things soliciting are a crime in Nevada, but anything conspiracy is a crime in Nevada. Conspiracy also requires the two parties to reach an agreement, two or more parties to reach an agreement. If you say, hey, Bob, let's go rob a bank, and Bob says, nah, not today, I'm not feeling like it, there's no conspiracy. Bob didn't agree. Notice that I didn't offer Bob anything of value to do it, so it's not solicitation. No crime has been committed. Now, same exact scenario, you say, hey, Bob, let's go rob a bank, and Bob says, heck yeah, bro, let's go do it. Now you've committed the crime of conspiracy. Obviously, there may be some proof issues. It might be difficult for the prosecution to prove conspiracy if you haven't taken an overt action towards completing it, etc. But just on a basic level, as soon as you and Bob agree to go rob the bank, the crime has been committed without any solicitation involved. If you say, hey, Bob, I'll pay you $100 to help me go rob this bank, that's solicitation. If he agrees, now there's conspiracy. And the solicitation still exists. Oftentimes you'll see conspiracy applied to actions by gang members. If a gang gets together to go fight another gang, that's a conspiracy, right? So and there's no solicitation there. It's just, hey, homies, let's go and gangbang with the Crips. All right, blood, let's go gangbang, whatever, yada yada. So that's the difference between conspiracy and solicitation. They can work together, but they're completely separate things. They get charged separately. They carry separate sentencing issues, etc. And then, as far as the model penal code is concerned, the model penal code is, as the name would suggest, a model. It is not the law. It never is the law. A state may adopt some or all of the model penal code, but that doesn't make the model penal code the law. Because when the state adopts it, whatever the state writes down on the page becomes that state law. It's no longer model penal code. It may be modeled on the model penal code. It may even be an exact copy of what the model penal code says for that specific section, yet it is not the model penal code anymore. It is now the state's penal code. So directing someone to the model penal code is to say, to say a violation of the Model Penal Code is a crime is nonsense. The Model Penal Code is important for aspiring attorneys, specifically in California, probably in other states, because aspiring attorneys are generally speaking tested on the Model Penal Code. They're also tested on common law crimes, so they're tested on both the common law kind of definitions of crime, and they're tested on the Model Penal Code. Just to make sure that the attorneys understand them and understand the difference between knowingly or intentionally or purposefully or willfully, because the Model Penal Code has purposeful, knowing, reckless, and negligent, and common law generally has specific intent and general intent, and states will have like California has intentionally and willfully and knowingly, and I mean it's a smorgasbord of various terms that you kind of have to be able to parse through. But for California, for the bar exam, they have on the MBE, the multi-state bar exam portion, the multiple choice portion, they test you based on, it'll say either Model Penal Code or common law crime. So you have to know both to do the multiple choice answers. And then as far as the essay portion of the California State Bar, they will tell you in the question that they're asking, that they want you to write the essay on, whether you're applying California law, you're applying Model Penal Code, or you're applying common law. So that gets a little even a little wonkier, because you got to know California law for the essays potentially. But of the common law, of the Model Penal Code, and of the California Penal Code, the only one that you can be convicted of violating, the only one that would be a crime to violate, would be the California Penal Code. So saying that it is a crime to do X, well, if that's not the state of the current state statute, it's not a crime. It's a theoretical crime in a theoretical state that has applied that portion of the Model Penal Code to its statutory list of crimes. Because the Model Penal Code is a fairly recent creation, and some states have adopted some, I don't know of any of that have adopted all, but some states have adopted some of the Model Penal Code. Some states are just entirely state statutes. They haven't adopted any of the Model Penal Code, and they just have whatever criminal statutes that have been around or adopted since the beginning of the state. Still, other states have some common law crimes still hanging around. They have some statutory and some common law crimes. Common law crimes aren't written down. They're not statutory. They're just crimes that the courts recognize, and you could still get convicted of violating them, even though they're not a statute. So saying something is a crime implies that a state or city or the federal government has made that a crime. The Model Penal Code is not a city ordinance, it's not a state statute, and it's not a federal statute. It is a model that a state may or may not choose to adopt in portion or in its entirety. So I hope that answers the questions. Probably not. I'm not going to do like a full 3-hour discussion on the nuances of these things, but suffice it to say that this whole stupidity that Michael Eline has been displaying started off because he wanted to be the big dick. He came in here, he saw that people were looking to me for answers about what was going on with Chile and why Chile's nonsense was nonsense. And he wanted to knock me down a peg. He wanted to cut me off at the knees. So he saw me talking about soliciting a trespass, which is a term of art in our community, wherein an officer goes and asks the apparent landholder if they want to trespass the auditor. That's what it means in this community. Not in the law at large, not elsewhere, but in this community, if an auditor is talking about you can't solicit a trespass, he's saying that a cop can't go and ask the landholder, whoever has apparent authority to trespass you from that property. The cop can't go ask that person if they want to trespass you. That's what the auditor is saying. Now, as we know, that's wrong. Even Eline agrees that that's wrong, but Eline, not understanding the subject, wanted to take me on that. He wanted to cut me off at the knees so that he could be the big swinging dick and he could show everybody about how he's smarter than I am, and so people would go to him to get legal advice. Whatever. It kind of backfired on him when I explained the situation and how he misunderstood the situation and how you specifically cannot commit the crime of soliciting a trespass in Nevada. And he has so it's amazing to me. People think that I refuse to admit when I'm wrong. And they get that impression because I mea culpa so fast. If I'm wrong, I'm like, mea culpa, I screwed up, right? And then people forget about it and move along. The problem with what Eline's doing is that he's compiling dumb after dumb after dumb after dumb. And the amount of accrual that's going on simply because he refuses to admit that he was dumb and wrong. This is going to be on the internet forever. Like, you're making a mistake. It was another attorney. I haven't watched his channel in a long time because I find trademark and copyright law to be so. Leonard French. Leonard French had a saying that I love, and he probably didn't come up with it himself, but I'm going to attribute it to him because I don't know who came up with it. But he said something along the lines of it: if you have to eat crow, it's better to eat crow when it's young and tender, or surely you'll eat it when it's old and tough. And Eline's going to have to eat crow when it's old and tough. He should have eaten the crow early when it was young and tender. He should have just said, you know what? I didn't understand the context. Sure, in the context you're saying it, great. It's sure. And everybody would have forgot about it and moved along. But here we are. Here we are with people hate watching your videos and coming to me to tell me how you got shit wrong all the time, Eline. And here I am having to sit in my car and educate people to correct the dumbass nonsense that you keep spewing. You should do better. Thanks for watching. Have a great day.